All right, welcome to estate planning education, Adam. I'm Paul over here.
Hey, Paul, and I'm Adam. Hey, folks, thanks for joining us and hanging around while we get everything rolling here.
Yeah, we appreciate everybody joining us. And for those in the future that are watching this, we appreciate you taking a little bit of time. And we think you're going to learn some helpful information on getting your estate plan started. If you think you're on an island because you have not um, done your estate plan, whether you have many children or no children, or you're a senior citizen, we our guess, which is completely anecdotal and not based at all on evidence, we're guessing probably 40-ish% of people have some version of an estate plan done. So that for those keeping score at home means that the majority do not, and
Right.
we're hoping to change that. So
Yep. Especially if you're in somewhere in the first 3 quarters of your life, it's probably particularly low. So yeah. So anyway, that's our goal here. As the title says, we're talking about how to get your house in order, get your affairs in order, and our goal here is hopefully some pro tips on making death less of a major bummer for those around you. And hopefully this presentation takes a little bit of anxiety away or a little bit of the mystery away from the whole thing. So that's our goal here. Let's go ahead and get rolling on it. All right. As we said, I'm Adam. That's Paul. Yes, we are related, for those who are wondering. We're out of Westlake, Ohio. Our law firm, Vincent Esquire, we focus on entrepreneurial clients, business and real estate, estate planning, and so those three things are the ways we help clients. They're generally positive transactions. We like helping people get their affairs in order. Anything else to add, Paul?
yeah, or if you're a Facebook friend or real life friend or family, reach out if you have questions. We like helping people. We're not expecting a legal fee for the questions about day-to-day needs, so feel free to reach out.
Yep. Yeah, it's great. So yes, we're licensed in Ohio. We're out of the Cleveland area. I'm closer a little bit to Akron, but happy to help guide you in the right direction, even if you're not an Ohioan. Okay, great. My usual space bar is not playing along. Have
Yeah,
fun.
that's me.
Okay, so here's today's goal. We're going to do a little bit of introductory overview. Um, we'll hopefully you'll have a head start on your on getting your affairs in order or your house in order. After this, you can kind of take a moment to think about your current status as we go through some of the questions that come up. And after today, we encourage you to finish that strong. Hopefully, today's a little bit of a springboard to get this all started. So first of all, we're going to learn from the rich and famous, some do's and don'ts. And then we'll talk about what estate planning is and what probate is, probate court. A huge thing we're going to talk about today, if nothing else, turn your ears on, probate versus non-probate transfers. If nothing else, that's a huge takeaway. We talk to people all the time about it. It's probably the most important thing to understand when it comes to making plans and getting your affairs in order. And then we'll talk about the four for everyone and a fifth for some. Those are trusts. And we can talk a little bit about business owner considerations, but we're not going to talk too much detail about that. If that's you, that's a longer conversation than today.
That's
Anything
right.
else to add, Paul?
No, moving along. For those that have never had a lawyer before, the attorney-client relationship starts when there is a fee agreement signed and most of the time money exchange. This is just for educational purposes only. What we say today may not perfectly fit your situation. So here's the boring legal disclaimer. This is for educational purposes only. This isn't legal advice. After this, we hope we've driven you to go find an attorney and get your estate planning done. But right now, we are not your attorneys for this legal work. No,
Well done. Why
thanks,
don't you
man.
talk about Prince a little bit while you're at it?
Prince, everybody knows Prince. I actually saw a video today that he played basketball with Kevin Garnett, and he's actually very good. So that was a new nugget.
Bonus.
No,
Fun fact.
bonus fun fact material for you guys. Yeah, so Prince, everybody knows he passed away tragically from a health concern, and surprisingly, a guy with that much wealth, with that big of a future, he actually had a new album coming out when this occurred, and probably because he was working himself really hard, that led to a dire situation. But anyway, he died without a will. He had no spouse, no children, didn't, of course, have any of his assets split up amongst anybody. His estate was worth almost as much as Adam's, $156 million. And it had to go through every little piece of it, had to go through the probate process. Not only do people like us who don't have $156 million estate have trouble going through the probate process because it's long and arduous and old fashioned and slow and pretty expensive and got to talk to too many lawyers. But and we all have like a couple things, that we got to work through there. This guy has all that intellectual property, real property, all that personal property, all sorts of different things. So over a long, long, long period of time, his stuff eventually got split up amongst his six half siblings, which hopefully he was as close as you hope one would be with your siblings, as maybe some of us are lucky enough to be. But more than likely, he had six half siblings, where at least some of them he would not have, when asked, wanted them to get a portion of his $156 million estate, because otherwise he probably would have put some stuff together. So, long story short, you want to put a plan together. You don't need $150 million to put an estate plan together, but you do need to plan, whether it's big
Yep.
or small. And so his assets got exchanged in what's called intestate. That means you go through the state organized statute that says, hey, when you pass away, it's going to go on this, what is that? Attestation, something? Tree
The
of
statute of
attestation.
descent and distribution.
Yes.
Yeah, and that's what I wanted to highlight was takeaway here is if you don't do anything, you die in testate is the probate court phrase for it, meaning you have no plans, and therefore the state, the probate court, has to follow state law, statutory law that says it goes according to your family tree, essentially. Depending on your state, most of them are the same. They start with spouse or kids if you have them, and if you don't, it goes up to parents, and then it works its way out. That's how half siblings wind up with it, or a distant cousin. The important thing that we want to take away here is, well, why is it important to plan? It's important to plan because if you die intestate, you have no control over that. It follows state statute. It doesn't know anything about your family. It doesn't know anything about your will, your preferences, what you would have. Has no idea if any of these half siblings had talked to Prince in any recent years, or if he would have ever wanted them to receive that hefty beneficiary take. So that's the important thing is if you don't get it done, it just leaves it up to chance or the state statutes. And so most people want to have a little control over that and avoid that chaos.
Bingo.
All right.
How
So
about one
that's
more
learning from
celebrity?
from Prince. How about from Aretha Franklin? This is yours, Paul, this
All
header.
right,
What is
yeah,
that? What are you
I'll
reading
let you
here?
run the slide, but I will take the song since it's hilarious and came
All
up from
right.
yours truly. Probate, where you don't want a messy estate to be. Wait,
Suck it to
hold
me.
for
Suck it to me.
applause. Hold for
That's it.
applause. Yeah. So anyway, Adam, run
Clear
through
the laughter. Hold for
an
laughter.
even weirder estate plan issue than
Yep.
Prince.
And the takeaway here, I'll cut to the chase, is plan properly, plan with advice of counsel, something Aretha didn't do. Aretha Franklin didn't formally create a plan for her estate. She wrote two separate wills on her own. Um, One will was found in a notebook under a couch cushion, and the other was found in a locked cabinet. Um, Created some chaos. One of the points is that the formal documents have to be executed properly. There was an issue there whether she had them witnessed. It seems like a law school problem of like, well, what does it mean to witness? What if a person doesn't see your pen hit the paper and all these silly law school things? So you can get kind of silly about it, but the reality of it is it does matter, especially in this case where she was creating wills apparently on her couch, and it led to a long 5-year court process. A jury had to figure out which will would control. Of course, she then again didn't have proper direction over that because she tried to do it but didn't do it properly. So, conclusion here is get it done, but also get it done properly as required by the law and with
Right.
direction of your friendly local
So
lawyer.
so she did better than Prince in that she was planning, but unfortunately, she's a great singer, not a lawyer. So she, of course, probably mucked it up a little bit. Who's
And
this
next we're
fine
we're meeting
lady?
another famous lady, a very
This is a good planner,
talented,
though.
great lady. Yeah, this is Velma Reed, our maternal grandmother here. So Grammy was a meticulous planner. She did an estate plan decades ago. She had bank accounts all set up. a really good secretary desk. She used to have everything very organized in all her notes, I remember. She had two lawyer grandsons. She wound up having her own probate opened by her grandsons after she passed away a few years back. And what happened was, honest mistake by a banker. She went into a care facility that required a certain bank account for her veterans benefit from a certain trust account. So when that was transferred over, the banker didn't list our mother, Velma's daughter, as a POD like she was on the previous account, and that was the issue that arose. It happens all the time. Things fall through cracks. So our point is, do the plan, do it with a lawyer, and do your best not to let things fall through the cracks. They do happen sometimes. So in this case, you were probably wondering, what is a POD? It's a payable on death. I'm glad you asked. And
Great
we'll
question.
get there in a moment. But before we get there, we're going to take a little step back to talk about some probate case basics before we talk about non-probate transfers like the POD. So we'll get there in a moment. That was a bit of a cliffhanger. I know people
Oh,
like those.
boy. Hold on to your seats.
So,
Hold on to your seats.
why don't you tell them my probate basics while
Yeah,
they sit on that edge of the street?
sure. So probate, what is probate? Probate is in the state of Ohio and across many states. It's a court that's authorized by law to transfer assets of a decedent to the correct beneficiary. When they're, like we mentioned earlier, intestate property, that means it's transferred just by the statute. So if you don't have a will or you don't have a trust or some other means to transfer property, a court will oversee it going from the decedent, the person just passed away, to the beneficiary, which oftentimes may be a surviving spouse or the children of the decedent, or down the tree from there. So um, the probate court is just there to oversee and ensure that the decedent's assets transfer where they're supposed to go. The new owner of the property gets titled as owner of that property, whether it be a car, a obviously real estate is a big one, other personal property, but the big ones are bank accounts, cars, um, and real estate. So, but does that mean, everything needs to go through probate? Another good question that you asked. Of course not. And
I
we're
was
going
going
to,
to sneak in there. I was going to try to raise my
well,
hand, but
now I'm going to kick it over
you
to you to
jumped right
talk
to it.
about non-probate transfers, and what those are.
So yeah, does all property go through probate? It does not, and that's thanks to our friends, the non-probate transfers. So probate case,
I
when
think you
something's
skipped
titled
one.
to a person who's passed away, what happens? Well, a court has to oversee that. There is the opportunity though to bypass that, and that's a non-probate transfer. But the probate basics are gathering inventory, just so you know what a case is, if it does actually go down that route, if it's not transferred by a non-probate transfer. If it goes to the probate court, the court just essentially opens a case. If there's an executor involved, that's named in the will, or if there is an administrator, um, that when there's not a will involved. Anyway, they open the case and they figure out, well, what do we need to get transferred out of the decedent's name? And that's called the inventory, gather up the assets. If there are claims by other parties that say that this estate owes us money, then they show up to the case. And then at the end, you make distributions to beneficiaries or claimants as the court sees fit. And so a transfer of ownership of everything owned by the estate, including legal claims. So that's one other thing, is if the person who passed away had legal claims that had value, that process has to go through, and that any value that might come out of those legal claims has to be part of the estate. So the estate is sort of a legal fiction, they call them. It becomes something that owns that property that's titled or owned by the person who has passed away and no longer owns it because of the death. So, does all probate go through all property go through probate? It does not. Non-probate transfers are coming right up. So, how can you avoid having to go through that process and um, and go through that time and all that sort of thing? Uh, Non-probate transfers are the answer to that. These are transfers as a result because of the death of a decedent, and they're not ordered by a probate court. They are they are the result of contract law and state law, by contracts and by law. So those are the two ways that you can transfer property outside of a probate court, and you can do estate planning through these non-probate transfers. So here are some examples. The POD we talked about. Why don't you talk a little bit about that, Paul, from good old Grammy, Velma?
Sure. Yeah, and Adam mentioned earlier on the cliffhanger, and I know you all have been anxiously waiting. Uh, when we had to move from one account to another, there was a payable on death account on the one, but when we had to open up the second one, the banker forgot to ask, "Hey, do you want to also have a POD on this new account?" Well, of course you would have. Of course, everybody would have, but nobody caught it. So, a payable on death designation is you going into your bank and saying, "Hey, do you guys have a POD form?" And the bank will hand it over to you. You'll fill it out. You'll direct the name, phone number, and addresses of the people that you want your account to be split into, whether that be one person or into multiple people. And then you turn that into the bank, and then the bank keeps record of it. They put it into their system, and then you now have a checking account that will transfer to the beneficiaries without the probate court's involvement. The next step that has to happen is one of those beneficiaries on the POD shows up with a death certificate, and the bank will cut the check to the beneficiaries. If it's you and you're the one that turns in a death certificate, they'll hand it right to you, or they'll mail off to the other. So that's a really easy but effective non-probate transfer that keeps a big headache out of going to a probate court for sometimes only a couple $100, which in that case, in Velma's case, we had to go for. I mean, it was more than a couple $100, but it was not much.
Yeah.
So,
Just enough to be a little bit of a headache.
yeah.
So yeah, so that's a non-probate transfer by contract. So again, that's the account holder's agreement or whatever agreement you contract you have with your bank or your account custodian. Another example of a transfer by contract is the life insurance policies that you have or your other account holder contracts where you're allowed to name beneficiaries of that policy or of that account. And you can, in the contract, give the names, addresses, whatever it is, and then maybe even percentages if you split it up evenly or unevenly. So those are transfers by contract. So it's good to know about those non-probate transfers. So again, you follow whatever the contract says. As Paul said, you just follow the whatever process the account administrator has, and that allows beneficiaries to receive that asset without having to go to a court and without having to get a judge to sign off on it. Then there are the transfers by law. They're created by law. Now, just because they're by law doesn't mean they have to go to a courthouse. These are things that are created in the statute and real estate law, for example. We'll take a look at a survivorship deed in a moment and a transfer on death designation affidavit. Those are two common ways that real estate is transferred outside of a probate court when someone passes away. You can also do a similar thing with automobiles that are titled with rights of survivorship, WROS, or where the owner has completed a transfer on death designation affidavit. Those are the very similar to things, real estate and automobiles.
And this is a good spot for anyone that has any of these assets. Do you have a payable on death designation on your bank accounts? Now, if you're married and you have a survivorship account with your spouse, you're in great shape. It's not a bad thing to go do it because in the unlikely event both of you were to pass away, then it would end up to your beneficiary, maybe your children or someone else. If you have work benefits like 401ks and other retirement accounts, have you updated those beneficiaries in a while? So use this little break in the action here to think on your own about what you have and whether you should set these things up. So,
yep, make a few notes. You can obviously create an inventory if you go into this and kind of get a list of all your different things. It's good to have in the files. It's good to have in case anybody has a spouse that doesn't know all of the accounts or all of the contacts for those accounts and where they're all at. So it's good to put one of those inventories together. But yeah, hopefully this motivates you to kind of think through what you have in place and what marching orders you have to get things in order. All right, so that was transfer by contract. Now we want to talk about the other non-probate transfer, which is transfer by law, and some examples of that. We just mentioned the survivorship deed. So in Ohio, if you go down to the recorder's office, most of them these days are going to be survivorship deeds when it's a husband and wife, for example. They're going to be held jointly with rights of survivorship, and there's going to be some language in there that references that. over time, thankfully, the legislature and courts have decided anything that tends to indicate that this person wanted to have survivorship, we should honor it that way. Doesn't have to have specific magic language. There's no specific magic words, but an indication that it's held jointly with rights of survivorship. That'll be in the granting clause on the actual deed that's down there in the recorder's office. So that's one example of real estate law. And then there's a transfer on death designation affidavit. This one's good, important to know about, especially if a homeowner is getting older and thinking about, well, what happens to the house? This is a way to do it without having the house go to the probate court, as we said. This is done through the recorder's office down where the deeds are. There are also things called transfer on death designation affidavits. The BMV has the same thing over in their files too. You can do one of these for automobiles. And on the next slide, we'll take a look at what one of these looks like. So here's one from Portage County, Ohio. Paul, want to talk about that one?
Yeah, that's excellent. But before we go, I do want to mention, some people are like, hey, I'll just transfer the house. Even though my health is good, I'll transfer it out of my name to my children. It's not a huge deal, but if you're concerned at all about the tax consequences of a transfer like that, when you transfer a house to somebody, like let's say you're living in it and then you live another 10 years. Well, if I were living in a house and I transferred it to Adam, and then I am going to, obviously I won't be living there anymore when I pass away 20 years from now, then Adam will have owned it for 20 years. If I transfer it to Adam today and it's worth 100,000, but 20 years from now it's worth 500,000, Adam's obviously got a pretty big tax consequence from having owned that for the 20 years. So not something a lot of people really spend too much time worrying about, but doing one of these transfer on death affidavits is a much better tax outcome as well for your beneficiaries rather than, hey, I'll just hand it over to my kids now. So just something else to keep in mind if you're trying to kick around what to do. Yes, getting back to it, this is, a lot of these acronyms that are used, people probably think, oh, only lawyers can do this stuff. I mean, lots of people do these things on their own. We don't recommend people do this on their own, but they're made up in a way so that non-lawyers can get this stuff done too. You'll see here on the left, it's describing what's happening here. It's both David and Cindy Vincent transferring their property. And then they put the legal description right in the middle there. That's not, that's something that will take a steep learning curve to figure out what you're supposed to put in. But below is how they want to transfer in survivorship to their wonderful children, Bethany, Paul, and Adam. So this is what they look like. Straightforward, very simple. The only thing that has to happen here for this to be executed is a couple signatures and a notary. And that's that. And in this case, now, when my parents die 50 years from now, in case they're listening at home, it'll just go to us three. And then we can all sell it and do with it like we want. So anyway,
Yep.
very simple, very effective, no probate court involved, only me, Adam, or Beth going to the recorder's office and getting it titled to our names after we hand over a death certificate.
Yep. And so this is an affidavit. It's sworn in front of a notary, and it's just them saying as affiance, as the people making this statement, this is what we want to happen. And again, this is a non-probate transfer under state law. State law establishes this is good enough to transfer the property. If they pass away and their death certificate's taken down to the recorder's office, and a new affidavit, let's say Paul goes down and says, here are the death certificates of David and Cindy, and then that affidavit that you record later on by the beneficiaries becomes a transfer document rather than going to a probate court and having a judge sign off that the new owners are A, B, and C. So that's a much easier way. It's a few bucks to record them, about 30 or 40 right now, usually in most counties. The other thing I want to mention and bring light to is how title of record at the bottom of page 1, title of record in the above property is held by the owners as follows: sole owner, tenants in common, and tenants in survivorship. So I only mention this, you don't have to know the distinction between the two, but if you got your home in Ohio in any time before the mid or late 90s, anytime before that, 70s, 80s, early 90s,
Anytime probably before 1990 or so.
check your deed or have a lawyer check your deed, because there's a chance that it's not held in survivorship. And from previous slides, one of the things we talked about tonight was you want that right of survivorship, meaning rights of survivorship means, of course, that it goes to the spouse that survives. After that, that spouse, the surviving spouse, has to decide what happens by recording one of these affidavits. But if you have it with rights of survivorship, there was a time there where everything in Ohio was done tenants in common between spouses, which meant a bunch of surviving spouses had to go pay the probate court $1,000, or a lawyer and the court money to transfer the house that they've owned for 60 years into their name individually when their spouse passed away. So um, the point here is if you don't have survivorship on your house right now and you're a married couple, if you don't know whether you do or not, confirm that. And if you don't, you got to get a deed. Just transfer it to yourself, but add that survivorship language. We did actually have to do that for this same wonderful couple, when about 10 years ago, when we realized they didn't have that survivorship language. So that can save a lot of headache. Check how your house is titled, and it should be, if your spouse is titled with rights of survivorship. All right. Anything else to add, Paul?
No purse.
Okay, non-probate transfers, probate versus non-probate transfers. An important thing to know about. We talked a lot about Grammy. I think everybody gets it, but don't let things
Another nice
fall through the
picture. Yeah,
cracks.
that was
Another nice picture.
that
Nice
was I
smile.
think my little Chloe's on her lap, probably back in 2010 or so.
Yeah,
So
that's nice. That's nice.
long time ago. All
Okay, so
right.
shifting gears, we talked about probate, non-probate transfers. Now let's talk about the four things to get in place for everyone.
Yes, I've done a couple videos on these four everybody needs. Doesn't matter how much money you have or how little money you have. Everybody can use this because it's a safeguard and catch-all to many of the problems that occur when someone passes away, especially if they're young and they have children. So we're going to run through the important pieces of these four. We'll touch on trusts at the end here, but let's get rolling here. The very first and the one that everyone's heard of is the last will and testament. This is an important document for a couple reasons, but this is, every state has their own statute. Some important things to think about it are how these are signed and who the witnesses are and things like that. But for our purposes today, some of the important things that get identified in a will is the executor. That's the person that's going to be working with the court and maybe a lawyer if they end up doing that, to work through the assets and make sure they all go where they're supposed to. When naming your executor, you want to be somebody that can do the job, someone that can handle it is some work, the work involved. So make sure it's someone that you think can do the job. It's a job, like I said, that has to go through and work through your assets, work through any debt you might have, pay off people that need pay off, pay taxes for the year that need taxes paid. So make sure it's somebody that can do the job.
Yep. Somebody that can understand and go through it, has patience, because it sometimes is a bit of a
Yeah, I
pain
mean,
in the butt,
and
slow
this is
process.
self-serving, like use a lawyer. I mean, there's no way I would ever go through probate court without dumping the stuff to a lawyer and having them deal with the paperwork because it's worth the money. It costs the estate some money. It doesn't cost you as a potential beneficiary or a child or something of the estate any money, but yeah, you should definitely do that. So another important part of a will is where the stuff goes. So if you don't have everything transferred by non-probate means, then you can obviously list where things go and the beneficiaries that would receive those. This is kind of the important stuff for parents of minors. You get to name the guardians. You get to identify the potential guardians of your children. So if neither parent survives something and there's minor children, a court needs to appoint the guardian, the kind of step-in parents of those children. In the will is where you get to identify who those people would be. Very important, obviously. You want to make sure that your guardians are decided on by you and then approved by a court. Now, I say that guardians need to be approved by a court. So, I name Adam as the guardians of my children. It would still require an application be made that Adam be the guardian. We'd submit the will and say, hey, Paul wanted Adam to be the guardian of my children. And then the court would wait, does anybody complain? Is Adam an idiot? Would he be a horrible step-in guardian? If nobody objects, then the court would likely appoint Adam as the guardian of my children, like I want in my will. Same goes for the trustee. A trustee is the person that handles the finances of those minor children. Oftentimes they're separate people, but they can be the same. A trustee will make sure that the kids are going to school. They're using, the monies that have come from the estate for the purposes of their, care and maintenance and going to school and stuff like that. So these are very important things, and these are reason enough. These two items on why we recommend everybody get a will done, because what you don't want to have happen is if tragedy strikes, and then now which grandparent's going to step in to be the guardian, which brother or sister is going to step in to be the guardian, family politics, family, fighting from 20 years ago, getting everything mucked up, and these poor kids being stuck in the middle. So you do the job, and you tell the court who they should appoint these positions to be.
That's right. And then you can obviously include some instructions for cremation and or funeral. Um, Follow state law. So two celebrities coming together. Prince would have left all this up to chaos. I don't believe he had any minor children, but if
Didn't
he
have any
had,
kids.
that becomes another issue. And then uh, Aretha didn't get the legal advice she needed. So again, be sure you're doing both of those things. Avoid the chaos and also avoid making mistakes that have unintended
And
consequences.
yeah, we're not going to have time to talk about it today, but you can identify your preference as far as cremation. There's actually a form for the state of Ohio too. Those aren't legally enforceable, but they are means to direct your surviving relatives, to do what you ask. So,
Yep. So then, yeah, the question about, if you die without the last will and testament, we mentioned earlier, if you don't, you die intestate, follows a state intestate statute in Ohio revised code. An administrator rather than an executor applies. They send out notice to family and go through the process there. Importantly, decedent doesn't have any control over that. The distribution of assets goes to beneficiary, and the timing and the splits of that. So um, you don't have control over who gets it. It's half siblings in Prince's case. You don't have any control over the timing of it. If you set up a trust through your will, or if you have a separate trust. But if you have minor children and just a will, you create something during the probate process. They create something called a testamentary will. It's what you put into your will along with naming of the guardian and trustee. You say create a trust, court, and you can give some general guidance on that and say if they're younger than 25, hold the assets in trust. It can be used for the health, wellness, and education. But then you can give an idea of that, and you can even say, and then distribute a quarter of it every 10 years or whatever you decide. If you don't have a will, you can't put that into place. You have no control over the timing of that. So distribution of assets could go to minor children. The timing is an issue, but it could be potentially for other beneficiaries depending on your situation. You have no control over the splits. Just even. They just make up as best they can what they think the split should be. And then you obviously have no influence over the trustee and guardian, as Paul was mentioning. The Ohio statute of descent and distribution is the one that follows the family tree. And I kind of described that earlier, following the family tree out from spouse, then children, then parents, and onward. All right. So that's the last will and testament. And what happens if you don't have one? Some of the examples of some of the things that happen. We again remind you to the will, as Paul mentioned briefly before, is a safety net. The goal is really to try to avoid that and think about how you can avoid having things go through that probate process. If you have minor children, though, and there are some scenarios you can't necessarily avoid it, but just keep that in mind as you're kind of putting all the pieces together, how you can have that plan, a full plan put together. Okay, so that was the last will and testament. That's number one. We always recommend for everybody. It's a safety net, and it's an important thing for parents to get into place. Next two documents are healthcare documents. You may get asked about these if you go to your primary care or any other healthcare provider, whether you have a living will or a healthcare power of attorney. So we'll talk about those next. I'll go through the healthcare power of attorney briefly, this is a document where you can name a, an agent, a person who can speak on your behalf. If you're in the event you can't make decisions yourself, or you're unable to speak on your own behalf, the healthcare power of attorney is a piece of paper that instructs healthcare providers who you trust to speak on your behalf and who should have access to your medical information in order to help make those decisions with the medical folks when you can't make them for yourself. So we all hope this never happens. We all hope it's a waste of time, kind of like insurance. We hope it's a waste of money. But in those events where it is important, it can avoid a lot of chaos. So that's a healthcare power of attorney. You name a trusted person to speak on your behalf and have access to your medical files and information and your medical providers. Healthcare power of attorney is number two. What's number three, Paul?
The living will. This is your directive on how you want your care to be carried out when you are in really, really bad shape in a terminal condition. It's very confusingly named. It's called living will. It's obviously concerns end of life care, so you're barely living. I don't know why they use living will. We already have a last will and testament. People call this people think what they're doing is a living will, but they're actually imagining that they're doing the last will and testament. So it's very confusing. But specific instructions, you get to decide on who gets to make that final decision for you. So if you're like me, you have completed your living will saying that I do not want to be essentially on machines during the end of my life. I once two doctors say I'm not going to recover, I have decided for me that I would like them to stop that care. The alternative to that is asking your healthcare power of attorney or a specific loved one or trusted friend to decide that for you. So what in that situation, it would be like, hey, if I did that and Adam was my healthcare power of attorney, the doctors would go to Adam and say, hey, Adam, Paul is, terminally ill. He's not going to recover. He's now on life-sustaining care with either, a machine of some sort. What would you like to do? And then Adam would be the guy to decide that I've had my fun. So I don't want that. I
Not
don't want
nice.
that. I don't
Not
want. I
nice.
don't want. I don't want my wife to have to do that. I don't want Adam to have to do that. I do that for myself. So that's what a living will does. Terry Schiavo is a case from when I was a kid in Florida. Two parents or two sides of the family fighting about whether she should be off life-sustaining care or maintain it. It was a fight over. What was it? Was it a almost a 12-month battle? Well,
I
this
thought it was years and years. I thought it was a decade, but I
Yeah,
don't know
I
the
don't know.
specifics.
It
Yeah,
was a long
it was
time. Look it up. Wikipedia will tell you. But
no
anyway,
fun.
but
We're looking
anyway,
for a story. Yeah.
yes. So
Yeah.
yeah, you want to get this stuff done because you don't want to make it any harder on anybody than it already will be when you're
Yeah.
no
We're
longer.
talking when tragedy strikes, we don't need any more chaos in that scenario. So put it down in writing if that's your will, if that's your intention. So let me reiterate something Paul said. The living will is not the last will. Pretty confusing there. And then there's another confusion, the healthcare power of attorney and the next one, which is the durable financial power of attorney. And people confuse this as and give it more credit than it is. If your power of attorney that somehow you have control over a decedent's estate or something along those lines. These don't impact the estate of a decedent. Um, the durable power of attorney, the word durable means during the lifetime of the person who's making that power of attorney, the principal of that power of attorney. So the principal who names the agent, much like the healthcare power of attorney, there's a person granting authority to somebody else, an agent, to carry out business in this case. So the financial power of attorney we can think of as the business side. Healthcare power of attorney is healthcare issues. This one is business issues and but not financial issues. For example, if you have a spouse or a trusted individual to speak on your behalf, it could be very broad. It could be everything. They can step in your shoes and do anything on your behalf if you'd like to be able to do that. For emergencies, healthcare crises, if you're out of town, those sort of emergencies. But again, it's void upon a grantor or principal's death. The person who made the POA passes away. That piece of paper has no more bearing on anything. And so some people get confused about that. that somehow that gives them the right to control the estate of the person or to transfer assets after the person has passed away, and it does not do that. So a little confusion there all the time people have is the POAs carry similar authority to like an executor in a will, and that's unfortunately not true and a common thing people get confused about. Um, so that's a broad power of attorney. There's important to also recognize you can make it limited. You can make it broad. You can make it limited to a specific transaction. So in business or real estate deals, somebody might do a power of attorney for having one particular person sign for a particular closing on a particular property. So these POAs can be as broad as step in my shoes and do anything to as specific as one single transaction. And so that's how a durable power of attorney can be helpful and help you avoid some chaos or problems down the road. So we had the last will and testament, the healthcare documents, or two of them: living will, healthcare power of attorney, and then number four is the durable power of attorney. So we had those four. We'll
Yep.
go through a
And
quick review here at the end
yep.
too.
And one other important thing to add for anyone that has children that are now adults, now they're adult children over the age of 18, you have if they're going off to college, this thing called the Federal Educational Rights and Privacy Act, where as a parent, when your children were K through 12, that was great. You had access to their entire educational record through the school. It was your right. You got access to it. You got to use it as you will. So when they turn 18, though, that right transfers from the parent and is now the right of the new adult, the child, where you have no more rights to those records. So um, I say this for obviously school, grades and things, but it's a good reminder that now that your children are adult children, you're going to need special and specific directives that you have access to their medical records, their educational records, their financial records. So you want to do one of these durable financial power of attorney and healthcare power of attorney. So if they go off to college or they're working and they bonk their head or they get seriously injured, you obviously want to help them make those decisions as 18, 19, 20-year-old kids. Without these documents, you're not going to be able to. Hospitals won't allow you. There are exigent circumstances where they will allow you. But if your child is stricken by mental health problems, you're not going to probably get to those records without a healthcare power of attorney. So use this if your children are coming up on 18 or they're in their 20s already and you've never thought of this before. Get those things done. It's in everybody's benefit that you have access to that information. So.
Yep. And if nothing else, encourage them to complete the documents with whomever they might name as their power of attorney, whether it's a sibling or someone else. But everybody should get this done. And yeah, as Paul said, a lot of people overlook it between the ages of 18 and 20s or early 30s.
Yeah.
But that's very important. All
Cool.
right, good. So those are the four. We're going to talk briefly about trusts, just so folks hear about it. It's obviously a common question here. Real quickly, what is a trust? Um, a trust is a basically can be thought of as a contract. It's a three-party fiduciary relationship, which means that people have responsibilities and are given guidance. It's basically a set of instructions created by a trustor or settlor. That's the person who creates it. They transfer property to the trustee. Oftentimes, that's the same party for the benefit of a third party, the beneficiaries, or third parties, plural. And so it's a set of instructions to say, we're going to create this thing that's going to own property, and here's a set of instructions about how this property should be handled and distributed to beneficiaries. So that's a short version of a trust. Paul, do you want to add anything else?
No, other than it's the most common way to stay out of probate court, outside of the other items we've already talked about today. So, if you're looking for a more specific plan for your minor children, a trust is a good idea. And if you have questions about this, it's best to not learn about a trust and how it can help you, in a quick webinar. It's probably something you want to talk to a lawyer about. So.
Yep. So we we'll go over a few more short points here, but like Paul said,
Yep.
there's some nuances to it, and it's not for everybody. Um, it spells out directions for handling property and distributions. It is drafted alongside what's called a pour over will generally. That's a good idea because the will becomes a safety net if something isn't transferred to the trust. If it's not funded, it's one way of describing it is if the trust isn't funded, if the assets don't go into the title of the trust, then the trust won't impact those things. So real estate that's not transferred through deed to the trust, that real estate isn't going to necessarily be impacted by it. Talk to a lawyer about your situation, but that's how it would be treated in Ohio, for example. Some reasons people get it is for privacy, again, control. If there's a significant amount of assets, you might need more control, and you might want to be able to spell out more specifics about how beneficiaries receive those assets. There is some ease to it. It's private. It's within the family. There's not a court oversight. You get some flexibility on how the different assets are transferred over time. You can be as specific as you want. So those are some of the pros of a trust. The cons are obviously that there's costs now. There's also costs later on to revise it or to administer it later. There is a little bit of risk when you don't have court oversight. You're very reliant on the trustee, especially subsequent trustees. That there's no court oversight involved there, and it's simply the trustee that gets to run the show. So obviously that requires some different calculations and planning. Anything else to add there for the trust,
No,
Paul?
yeah, no, it's good.
Okay. And then there's, people put these together when they have a particular amount of assets or they want to have particular benefits like privacy and control. And then also obviously special needs trusts. There's some Medicaid planning can be involved. Those are two other common ones. Talk to your lawyer about whether those are a good fit for you. Okay, great. Key
We're coming
takeaways.
to a close, people. Wake up.
We've talked about a lot. 48 minutes. Yeah, wake up. Here they are.
Wake up. We're wrapping. Hey, we said 45, so I mean, we're pretty honest about it. So that's
We did
good.
pretty good. We did pretty good. So there are
And we're both
trusts.
we're both awake, so that's
Yeah,
cool.
I mean, sort of.
Sort
Uh,
of.
Probate, non-probate. Hopefully, you picked up that the importance of how you can plan and avoid the probate process through some of those contractual and statutory things in contracts that can avoid probate, setting up accounts and those sort of things. Um, some non-probate transfers by law that are created through statute, like survivorship deeds and transfer on death designations. Um, don't forget, it's important to plan ahead. We all know that. Prince showed us that. Aretha told us we got to plan ahead with the advice of a pro. Be sure we're doing it right. And then one other little bit of advice we always encourage people to do is to put it on the calendar. We all know this is a bit of a bummer. It's the last thing you really want to do for most people. And so you put it off until next month or next week, and then it becomes next year. So try to make some headway every couple of weeks. Maybe make a little reminder on your calendar, or either repeating monthly, or maybe even just on your birthday. It's a good time to think about life every year and maybe making some headway there. So put a calendar event sometime and try to make some headway to reach out to somebody about your plan or look into your accounts that you have set up. We have a form that's an inventory. We have a very exhaustive one if you're really into being meticulous about it. If you're a Velma Reed, where you can document all those things. It's a good thing to do, especially for spouses, so that everybody's on the same page when it comes to all the accounts and all the different contacts and representatives and all those sort of things that maybe you don't have in one single place. All right. Anything else to add, Paul?
Only that we appreciate you guys making through this. And as a treat, Adam mentioned the inventory. We're happy to send that over. But if you're an Ohio resident and you've made it this far, whether you've just fast forwarded to this point or not, that's fine.
Yeah.
We don't blame you. If you when you reach out to us about getting your estate plan done, if you say Aretha Franklin
PRO,
during
sing it.
PROBATE, you want to get your estate planning done. You say
Spoken
Aretha,
word performance or musical performance. We'll take either.
yeah, you say Aretha Franklin when you reach out. We will do your estate plan for half. because we're that kind of guy. So anyway, we just want to help people get this stuff done. That's why we do this. And we feel better when people knock it out, and they will feel better. So you will feel better. So if you say Aretha Franklin or some mention, even if you mention Prince, you're like, I don't know which one you were rambling on about. Any mention of getting to the end of this thing, we're happy to take care of you and help you get this stuff done. So
Yep. Thanks again, folks, for your time. We're happy to help however possible. Feel free to reach out to us here at Vincent Esquire.
thanks a
All
lot.
the best. Bye bye.